Welcome to the Sections on European Law and Defamation and Privacy Laws joint program. The title is Comparing Data Protection Structures in the European Union and the United States. I am Professor Kristen Barnes. I'm a professor of law at Syracuse University College of Law. I'm the chair of the European Law section, and I am co-moderator for this panel. This program offers a comparative examination of the regulatory regimes of the European Union and that of the United States concerning data privacy and security. And we have an exciting group of panelists lined up to share their expertise with you. In terms of how the panel will run, the co-moderators will introduce each speaker in turn and will hold all questions until the end of the session. I'm going to turn now to my co-moderator, Randolph Robinson.
Thank you, Professor Barnes. My name is Randolph Robinson. I'm an assistant professor of law at the University of Illinois Chicago John Marshall Law School. And I'm very grateful to be here today and for Professor Barnes' leadership in putting together what I think is a fantastic panel. As most folks who are attending probably know, the issue that has dominated much of the discourse in privacy and data protection law, I think on both sides of the Atlantic over the last couple of years, has been the introduction of the GDPR. And then the lingering questions as to what we will do here on this side of the pond to move forward what I think many of us view as being kind of a lackluster privacy regime that we have. So I'm very excited to hear from our esteemed panel today. I think these folks have some great ideas. And I'll throw it back to you, Professor Barnes, to introduce our first panelist.
Thank you. Our first presenter is Professor Stacey Ann Elvey. She is a professor of law and the Martin Luther King Jr. Hall Research Scholar at the University of California, Davis School of Law. Professor Elvey has published widely in the areas of privacy law and security. The title of her presentation is from her forthcoming book, A Commercial Law of Privacy and Security for the Internet of Things, which is forthcoming from Cambridge University Press. Professor Elvey.
So thank you, Professor Barnes. So as Professor Barnes just mentioned, my talk today is based on my forthcoming book titled A Commercial Law of Privacy and Security for the Internet of Things, which will be published this March by Cambridge University Press. So the book explores the consumer implications of the Internet of Things through the lens of commercial law and privacy and security law with a primary focus on corporate conduct. The book's arguments can really be broken down into 4 points. So first, I argue that despite the IoT's possible benefits, it disrupts our privacy across a large range of contexts, raises significant data security concerns, and further enable corporate digital domination. Many existing privacy and security law frameworks, I argue, cannot or do not fully remedy these concerns. Second, I also argue that various commercial law frameworks can exacerbate and further enable the privacy, information security, and digital domination concerns that the IoT raises. Commercial law provides various vehicles for the collection, transfer, and disclosure of our data, while in some cases allowing companies to shield themselves from liability. Third, I offer a comprehensive set of solutions in the book to address deficiencies in the covered sources of privacy, security, and commercial law. Fourth, the book offers several non-exhaustive reasons that in combination could explain the seeming disconnect between privacy law and commercial law and the consumer concerns of today's connected world. So in other words, I attempt to shed light on why these legal frameworks are possibly inadequate. So all of these reasons, I argue, likely coalesce and contribute to a setting that allows corporate actors to use commercial law frameworks in some cases to advance their interests, right, at the expense of our privacy and security. Now, one explanation that I offer in the book is that despite the overlap of some concepts in both the commercial law and the privacy law fields, right, privacy law and commercial law have historically focused on primarily addressing a distinct set of questions. So, for instance, unlike privacy law discourse, which has predominantly explored questions and claims related to knowledge, access, and the use of information about us, commercial law has long had a heavy focus on issues related to trade, right, involving individuals, merchants, and other entities. However, privacy law, I argue, and commercial law are increasingly overlapping in the IoT world. This melding of the privacy law and the commercial law world obviously predates the Internet of Things, the IoT, but the IoT, I think, think, exacerbates the consumer concerns that arise from privacy laws and commercial laws' inadequate recognition and resolution of the issues that are caused by the growing overlap. Now, another related reason that I offer in the book is that despite what appears to be distinct inquiries, both commercial law and privacy law historically reflect varying levels of deference to or respect for corporate practices. Now, this deference has likely contributed to an environment that allows corporate actors to use both bodies of law to serve their own interests, right? So in the privacy context, this deference, as we know, has taken the form of a self-regulatory approach to data privacy and notice and choice, right? So as we all know, notice and choice has historically dominated the U.S. approach to consumer data protection. Powerful tech companies have in some cases played a significant role in blocking proposed consumer privacy and security laws while advocating for more self-regulation and for more notice and choice. The privacy notice and choice regime, surprisingly, has also to some extent been duplicated in the commercial law arena as well. And the perfect example of this that I talk about in the book is the 2005 amendments to the Bankruptcy Code. Now, outside of privacy law's influence, commercial law has for some time also displayed a high regard for the development of commercial practices. This respect for business customs appears to go beyond a mere recognition that commercial practices will evolve over time, right? So deference to commercial practices is evidenced by the UCC, the Uniform Commercial Code, right? So if you look at Article 1 of the UCC, for instance, it states that one of the core purposes, quote, of the code is to permit the continued expansion of commercial practices. Now, given that one of the underlying purposes of the UCC is to facilitate the expansion of commercial practices, the development of modern commercial practices involving data trade arrangements, right, and the potential applicability of the UCC, the code, to these types of transactions is in keeping with that goal. Right. So this esteemed view of commercial practices, combined with the role that corporate advocates play in the UCC revision processes, the UCC's goal of uniformity, and the mechanism for the approval of UCC amendments. These things may explain why the UCC has not yet been revised to more adequately address or reflect consumer concerns. Now, although there are certainly several provisions in the UCC and the code that directly address consumers, the UCC on a whole has not been very welcoming to consumer protection issues. Commercial law frameworks have struggled to adequately address technological developments and also to address commercial law or consumer protection concerns, right? And in notable cases, attempts to do so have not been very successful. Now, the examples I discuss in the book include the 2005 amendments to the Bankruptcy Code that I mentioned earlier, as well as the failed Article 2B of the UCC project, which resulted in UCITA. So today, there's an ever increasing blurring of the line separating the privacy and security law world and the commercial law world. The rise of the computer, modern databases, big data, companies' free and freemium data business models, and other types of business models, right? And now we have the IoT. They've created an ever increasing overlap between privacy law and security law, right, and commercial law. And these business and technological developments have pushed us deeper into the realm of what I describe in the book as the commercial law of privacy and security. And the result is that our concerns about privacy and security are intricately connected to the commercial law frameworks that allow companies to exploit our data. So in today's connected world, our concerns about who should know us and how they should know us are determined by the privacy law and the commercial law frameworks that govern consent and firms' data collection, monetization, transfer, and disclosure practices. Now, commercial law and in some cases corporate law frameworks are directly implicated by the pressing privacy and data security questions that the IoT raises. So some of the questions that I explore in the book include how the law in our society should respond to and evaluate, for instance, first, the proliferation of the IoT and firms-related implementation of business models and product design and data practices that in combination work to continuously surveil our activities. Second, the extent to which existing commercial law and privacy law frameworks should be adjusted to adequately remedy privacy and security concerns in the IoT age. Third, consumer consent to companies' data practices, including in transactions that are potentially subject to Article 2 of the Uniform Commercial Code and the implications of that consent. Fourth, companies' use of asset collection technology and IoT devices to digitally dominate and restrain our activities in lending transactions, including transactions that are potentially subject to Article 9 of the Uniform Commercial Code. Fifth, companies' possible use of our data and rights associated with these data in secured financing transactions under Article 9 of the UCC as well. And lastly, I also covered businesses' disclosure and transfer of our data in bankruptcy proceedings. So as I mentioned earlier, the world of commercial law and the world of privacy law are now inescapably linked together in a marriage of sorts, right? So commercial law is a crucial source of corporate power in the IoT era. So for instance, it is commercial law that gives teeth to privacy law's notice and choice framework, right? It's commercial law's inability to sufficiently grapple with the privacy and security issues, right, that has allowed companies to exploit privacy law's heavy dependence on the notice and choice regime to extract significant rights from our data. And it frequently blesses corporate data practices. So it's the contract law and the lending frameworks of commercial law, I argue, that allow corporate actors to use IoT devices and various other technological developments to extend their domination over us in various transactions, right? It's products liability laws and the UCC's inability to account for the interconnected nature of IoT devices, services, and systems, as well as other technological advancements that allows companies to be free from various forms of liability for privacy, security, device failures, and digital domination harms. Similarly, it is the UCC, the Uniform Commercial Code, the Bankruptcy Code, and other sources of law that enable firms often to opaquely and easily transfer and monetize our data in corporate transactions, potentially solidify their market power, and consolidate our data primarily to advance their interests. So as I discussed earlier, many of the privacy and security harms that the IoT raises lie at the intersection of privacy law. It lies at the intersection of the privacy and security law world and the commercial law world. So what I call the commercial law of privacy and security. Now, the book offers a two-pronged comprehensive approach to address inadequacies found in various sources of privacy and security law and commercial law, and to better account for the increasing overlap between commercial law and privacy and security concerns in the IoT setting. So first, as we know, the lack of a comprehensive privacy legislation has made the U.S. an outlier in terms of comparing us to regulatory approaches in other parts of the world, right? And weak sectorial federal privacy laws, coupled with the absence of a federal statute that establishes baseline privacy rights, has fostered an environment in which companies are oftentimes free to collect, disclose, and monetize consumer data. So the book joins earlier recommendations in support of relying on some aspects of the European data privacy and security approach and reformulating the U.S. approach to privacy. I also argue that some provisions from other U.S. domestic frameworks are also potentially useful sources as well. Federal legislation can shed light on permissible data practices and impose prohibitions on certain data-related activities. A comprehensive baseline and privacy information security federal statute that does more than just mandate notice and choice, and that establishes the contours of acceptable and unacceptable data practices could be a key step in better safeguarding consumer interests. Federal legislation can also address current and possible future concerns that result from existing legal frameworks' inability to sufficiently account for the blending of the commercial law and privacy law worlds. And as we know, the FTC, the U.S. Government Accountability Office, some academics, consumer advocates, and others have long recommended that Congress adopt various versions of a comprehensive federal privacy and security statute to better address privacy concerns. Now, even the FTC in the IoT context, even the FTC has acknowledged that the privacy and security harms that the IoT generates provide further evidence of the pressing need for Congress to adopt a general privacy and data security statute. Now, there are several GDPR and CCPA-like rights and legal obligations that I talk about in the book that could be incorporated into a federal baseline statute. Federal legislation could also explicitly require, rather than simply merely recommend, data minimization and privacy and security by design and default. So privacy by design in the IoT setting should to some extent mean that strong privacy settings are implemented by default, right? And devices are designed to function without always having to connect to the internet and collect and transmit our data. A privacy and security by design could also restrict large tech giants' ability to require smaller IoT device makers to design devices to send them continuous streams of data. So as I mentioned earlier, I argue that a comprehensive two-pronged approach can help to reconcile provisions in commercial law and privacy law frameworks that potentially enable consumer harms. So in addition to joining earlier calls for the adoption of a baseline privacy and security legislation at the federal level, I also propose revisions to important sources of law governing commercial activity, such as the UCC, the Uniform Commercial Code, the Bankruptcy Code, as well as products liability law. So I'll briefly talk about two of these recommendations before I conclude. So with respect to products liability law and the warranty principles that are contained in the UCC, I recommend that courts and legislatures adopt what I describe in the book as a functional approach to products liability law and warranty law that accounts for the vital role that services and software play in IoT device operations. Now, lastly, I also argue that the Bankruptcy Code can be amended to more effectively address data transfers in bankruptcy proceedings and to correct the over-reliance on notice and choice that has been imported from the privacy law world. So, for instance, the Bankruptcy Code could be amended to require that courts appoint a CPO, a consumer privacy ombudsman, whenever consumer data is potentially up for sale or transfer in bankruptcy proceedings. So, in other words, a CPO would get appointed to provide guidance to the court on whether the transfer and disclosure of the data should be approved, even if the company has no privacy policy, even if the consumer has consented potentially to terms and conditions or a privacy policy, right? And even if the privacy policy or terms and conditions contains provisions that would authorize the disclosure and transfer of the data during corporate transactions, including potentially in a bankruptcy proceeding. So to conclude, the volume and types of data about us that are now more easily available to companies has increased exponentially, right? What does the IoT's proliferation mean for us as consumers? The book seeks to answer this question by highlighting the different ways in which commercial law impacts the pressing privacy and security issues that the IoT raises. And the book, again, offers a comprehensive two-pronged approach to usher in a more robust commercial law of privacy and security to better protect consumer interests. So I'll stop there, and I look forward to questions during the Q&A. Thank you.
Thank you very much, Professor Elvey. Very interesting, and as these IoT devices continue to proliferate and become a bigger part of our lives, very important issues to look at. So I really appreciated that presentation. I'm going to take just a minute to introduce our second presenter, Professor Neil Richards. Professor Richards holds the Cope Distinguished Professor in Law at Washington University Law, where he co-directs the Cordell Institute for Policy and Medicine and Law. He's also an affiliate scholar with the Stanford Center for Internet and Society, the Yale Information Society Project, a fellow at the Center for Democracy and Technology, on the board of the Future Privacy Forum, and a member of the American Law Institute. Professor Richards.
Thank you, Rand. I want to start by thanking the panel organizers, Randolph and Kristen, for having me here, and to my co-panelists, Stacey Ann, Margot, and Oreste, for what's going to be, I think, a great discussion. Now, there are so many interesting issues raised by the comparative data protection structures in the US and the EU, at least interesting to me. For example, whether philosophical debate, for example, including philosophical debates about the meaning and importance of privacy, or the tremendously important practical issues of cross-border data transfer raised by the Schrems line of cases, which I hope we will get to in the Q&A. But I want to focus my short remarks today on privacy reform in the United States and the prospect of what some are calling a US GDPR, which would be, as Stacey Ann mentioned, a comprehensive data protection statute modeled along the lines of the GDPR for the United States. Now, my argument is going to be straightforward. The GDPR is undeniably the emerging international gold standard for human protective privacy and data protection law, and there's much to admire in the GDPR. In fact, the US could do much worse than adopting an American GDPR. But the US could do better as well. The GDPR is not perfect, and any American version of the GDPR is further likely to be a GDPR light, a watered down version of the GDPR. In fact, some versions, some proposed versions of an American GDPR light could actually be worse than the admittedly flawed system of data protection that the United States has right now. So while the US could do worse than a US GDPR, it could do better. It could pass trust-enhancing substantive rules, which in my opinion should include a duty of loyalty in some form. And I should say at the outset that these arguments that I'm going to be making today rely upon published and draft work that I've done with Woody Hartzog of Northeastern, particularly Privacy's Trust Gap in Yale in 2017, Privacy's Constitutional Moment of Limited Data Protection in Boston College Law Review in 2020, and a draft paper called A Duty of Loyalty for Privacy Law, all of which can be found on SSRN. So the first claim I want to make is that the US privacy law at present is woefully insufficient to protect human beings in their use of their data by companies. American law is better, but still insufficient when it comes to the government, but that's outside the scope of what I want to talk about right now. So as Professor Hartzog explains in his fantastic book, Privacy's Blueprint, you can boil American privacy law in general down to 3 basic rules. First, don't lie about what you do with personal data. Second, don't cause demonstrable harm, particularly economic harm, by using personal data. And third, follow some basic notion of the Fair Information Practices, or FIPS, even if that means constructive notice and fictional choice. Now, there are, of course, exceptions. HIPAA's system of data protection for some health data is much more robust, for example. But those are the 3 basic rules. Don't lie, don't harm, and follow a weak form of the FIPS. So, second claim I want to make is that the GDPR is much better than the current US model. The GDPR, like the directive before it, rests upon not 1, but 2 fundamental rights of privacy enshrined in the EU Charter. And the GDPR model of data protection has undeniable virtues. It is refined and sturdy. It represents the product of great wisdom, effort, hard work, and political compromise by Europeans and others over the decades. The GDPR offers a pathway towards global conformity and interoperability. It's not just that the US is an outlier when it comes to not having a data protection statute. It's that the GDPR model of data protection, the GDPR brand, if you will, represents an emerging global standard, not just a legal standard, but a business standard, that if you want to do business in personal data, you have to at least be conform yourself to the GDPR to enable international interoperability. And in addition, the GDPR is formidable and it's empowering. It rests upon this notion of informational self-determination, that people should be in control of their data, that they should be able to make privacy choices and to exercise their capacities as autonomous beings with respect to their data. So I don't want to belabor the virtues of the GDPR, because I want to focus on my third claim, which is that a US GDPR will not be enough to deal with the problems that are raised by human information technologies, either now or in the near future. The FIPS, first of all, and really the GDPR model that the FIPS embody, assume that data processing is almost always a worthy goal, right? It provides at least in its US form, a recipe, a set of instructions for if you want to do a certain set of operations on data, here are the steps that you need to go through. Whether or not that's equally true in Europe, it's important to recognize that the United States is not Europe, and I don't mean this in a good way. In Europe, as I've mentioned, data protection is a human right, and as such, it's able to stand up to countervailing interests opposed to data protection, whether they're ones of business efficiency or profitability, or claims rooted in other fundamental rights like free expression of the sort that we see lodged in Europe against the right to be forgotten, and of the sort that we're going to be seeing increasingly in the United States, not just against American versions of a right to be forgotten, but against the very enterprise of data governance itself, under a line of cases stemming from the resurgence of digital Lochner and most prominent in in the Sorrell case decided by the Supreme Court a few years ago, and raising its ugly head once more in a challenge brought to Illinois' Biometric Information Privacy Act by the Clearview AI company. So as such, because it doesn't rest upon fundamental rights, a US GDPR is likely to stand on a much weaker normative foundation than the GDPR does. And it is inevitably going to be a GDPR light. And that's even before we get into inevitable inside the beltway political issues of dilution and compromise. Furthermore, given the Senate filibuster rule, this is going to be the case even if the more data protection friendly Democratic senators win both Georgia runoff elections today. And you can see this in the two main data protection bills that are currently enrolled in the US Senate. The Democrats' Cantwell bill is stronger than the Republican bill drafted by Senator Wicker. But both the Cantwell and Wicker bills are significantly weaker than the GDPR model, and either of them would represent a GDPR light. And even beyond politics, there are also constitutional differences that would push the US inevitably towards a GDPR light. There are First Amendment objections, which I've already discussed. There are also objections stemming from Article 3 standing in any private right of action that is built into a US version of the GDPR. It will be more difficult than in Europe for American privacy plaintiffs to seek relief because of not just of the existing structures of Article 3 standing that we see in cases like Clapper and Spokio, but really the tightening of the availability of the federal courts to federal plaintiffs in privacy and other cases that we've seen over the last 30 years. And I think we're going to increasingly and inevitably see with the increasingly conservative, rights-unfriendly federal judiciary that the last 4 years have left us with. So finally, the notion of data protection is myopic. The FIP regimes, like the GDPR, conceive of data processing as a virtuous goal, which has the consequence of normalizing surveillance, processing, and procedural rules at the cost of more substantive protections. Data protection regimes also fail to account for data externalities like environmental harm, attention theft, and the degradation of our social interactions. And this is a problem because we're only just beginning to see the human and social costs that are associated with the massive scale of data processing and platform dominance. In addition to core privacy-related harms associated with data collection and use, companies have an insatiable hunger for personal information that is negatively affecting our attention and how we spend our time, how we become educated and informed citizens, and how we relate to each other. And we see this in phenomena like fake news, deep fakes, non-consensual pornography and harassment, addiction by design, and lives that are spent blankly and bleakly staring into our phones. These are at least partially byproducts of or made worse by the human data industrial complex. And this is to say nothing of the toll that these products inflict on our natural environment. So we need broader frameworks, not just because human data is personal to us, but because the incentive to exploit human data creeps into nearly every aspect of our technologically mediated lives. Data protection regimes are thus myopic, that the fair information practices are too focused on individuals, control, and consent, and they're not nearly focused enough on relationships and power. Moreover, the control and informational self-determination that is sought by data protection regime, these classic ones, are essentially impossible in constructed environments where choices are constrained, engineered, and overwhelming. And that's particularly the case as you multiply the sheer volume and scope and context of all of these choices that consumers are demanded to make every day. When privacy is thought of solely, or even primarily, in terms of control over data, regulators risk becoming blind to other values served by broader notions of privacy and other mechanisms like design that can be used to corrode people's autonomy. Privacy is about more than atomized decisions. It is about how power is distributed and wielded, and we should regulate it as such. And this leads to my fourth and final claim, which is that while the US could do worse than a GDPR, it could do better. In fact, I think it should do better. And the framework that Hartzog and I have in mind would have four elements. So first, there should certainly be a data protection element to any US approach to information governance, but that's not enough. Second, in terms of thinking about the problems of informational and surveillance capitalism, we should look to the tools of corporate regulation, both antitrust and veil piercing, were appropriate, as well as some of the commercial tools that Stacey Ann was just talking about. Third, and this is where my work with Hartsout comes in, we need to develop an approach to privacy and to data protection that deals more directly with power and relationships and promotes trust. We believe that any such system must create incentives for companies to behave in a trustworthy manner when it comes to human information, which means directing them to be honest, discreet, protective, and above all loyal, putting the interests of their human customers ahead of narrow, short-term profitability, data extraction, and manipulation. And fourth and finally, our law should deal with some of the external consequences caused by human information processing, such as its effect on our mental health, our democracy, our civil rights, and on the environment through pollution and carbon emissions. Now, I realize that this is a lot, but I think it's also important to recognize that we're in the midst of an informational revolution that is every bit as transformative and dangerous as the Industrial Revolution was. And we need thoroughgoing, comprehensive reform to make sure we take advantage of the benefits of digital technologies while we minimize their undeniable risks. And we actually seem to be right now at a point where privacy reform is a realistic possibility in the United States. And it would be, in my opinion at least, a real missed opportunity if the US were to pass a weak GDPR light, particularly one that's preemptive of experimental state laws, to declare the problem fixed and to ignore these problems for another generation.
Thank you, Professor Richards, for a really enlightening discussion. And hopefully we'll get a lot of questions from the audience so that we can get some good discussion going. I also wanted to encourage the audience to type your questions into chat. We will be addressing them at the end of the program. Our next speaker is Professor Oreste Pollicino. Professor Pollicino is a full professor of constitutional law at Bocconi University. He is a board member of the European Agency for Fundamental Rights, and he has written extensively in the areas of data privacy, the internet, constitutional law, and human rights. The title of his presentation is Digital European Privacy at the Mirror, Inner Tension and Possible Way Forward. Professor Pollicino.
Thank you very much, Professor Barnes. I'm really happy and grateful to be here, and let me congratulate for this really laboratory of comparative law in action with regard to data protection. Really fascinating. I will try to contribute with a few questions related to the issue of which distance are today between the two sides of Atlantic in terms of data protection, and which distance are shortening and which are increasing. Those are the research questions. We try to answer together with Professor Fernanda Nicola in West Virginia Law Review last issue by outlining how what we call Balkanization of data privacy regulation is not only related of a kind of, let's say, new spring coming from California, the California effect, which is spreading rapidly across the United States jurisdiction through the California Consumer Privacy Act. But there is also another side of Balkanization, Balkanization seen from the GDPR perspective. Why? Because as Professor Richard really in a splendid way put it before, from a far perspective, could appear that the ideal model GDPR, it's in a way letting emerge harmonization and uniformity. But from a closer look, will appear that there is still there a lot of fragmentation, a lot of Balkanization due to a simple fact that very often is forgotten. The GDPR is in fact a hidden directive with 69 open clauses that are left to the marge of member states. This means basically that from directive we move to another directive, and this is also a reason of fragmentation. Another reason of fragmentation, in a way, the fragmentation is the first convergence between the two sides of Atlantic. In Europe, is due also to the legislative inertia that made very long the way, the paths to GDPR. In the meantime, European Court of Justice played the lawmakers with some decisions. Few have been already recalled. Others I will name later. That in a way challenge the principle of legal certainty, because a case-by-case approach of the court will never be the right answer to the ideal uniformity coming from the legislator. There is the second convergence path that is due to what I call the broken promise, or the discovery of fairy tales in Europe. The fairy tale is basically due to the illusions in 95, that when there was adopted the directive that was mentioned in Europe, you'd have allowed the control, the real self-determination of data subjects. It was a really illusion. Why? When we moved from the words of atoms to the words of bit, the discovery was that the data subject can dream about having a real control of its data, of her data. And which was the alternative? The alternative was, if it's not possible to have a control, at least injects some value, some economic value to data protection. What does it mean? It means that it was emerging a new relationship that you know very well in the United States between consumer law and data protection law. Few years ago, it would have been a blasphemy dealing with this relationship. It would be a very, very dangerous relationship. Why? For the reason that's been mentioned before, the fundamental rights narrative in European constitutionalism doesn't allow for injection of monetization. But when the discovery was done and the fairy tale was discovered, then the last solution was to inject some consumer law protection. Then there is something that will never be convergent and is still maybe less distant than before. I'm dealing with the two First Amendments, the First Amendment in the United States Constitution and the First Amendment in the European Constitution that I will mention later. With regard to the First Amendment of the United States Constitution, you know much better than me that Section 230 and the preservation of light platforms related to right to free speech, it's totally illustrative to the defense that American legislators and American courts give to the First Amendment over consumer data protection interest. I can just mention the Carafano case, 9th Circuit 2003, but I can go also further in order to show how the allegation related to violation of privacy are always, very often, totally override by First Amendment, and especially that holy immunity that maybe is not so holy today of 230 section. What about European context? The real Fourth Amendment of the real First Amendment of the European constitutionalism is clearly the data protection fundamental rights. Article 7 and Article 8 of the Charter of Fundamental Rights of the European Union, and especially how those rights have been developed, I would say even manipulated by the Court of Justice in the judicial activism season that I was mentioning earlier. As you know very well, this season has been in a way related to three main judgments. The first one has been already mentioned by Professor Richard, Schrem's case, 2015. I would like to mention Digital Rights Ireland, 2014, April 2014, in which basically the European Court of Justice is training as a constitutional court. Is training as constitutional court by striking down an entire piece of secondary legislation because of the violation of the Bill of Rights, especially Article 7 and Article 8. So the digital privacy becomes a privileged, I would say, playgrounds in order to train the European Court of Justice as constitutional court. And then we have Google Spain. Google Spain, it's very, very important in relation to the judicial activism of the European Court of Justice, because in a way, what's happening, it's exactly what Professor Richard was mentioning before, that there is a totally different vision of free speech. It's not a holy right, but is a right that is doing a stepping back in order to protect fully data protection. In that judgment, that by the way, it's a balancing between freedom to access to information and data protection, is never mentioned free speech, Article 11 of the Charter, but is obsessed mentioned Article 7 and Article 8 of the Charter of Fundamental Rights. What does it mean? It means basically that the European Court of Justice in a period had to play the role of lawmaker. But then something changed. It changed basically that the GDPR entered into force. And as Federico Mancini, one of the most prominent judge of the golden age of the Court of Justice was saying, every time that the European legislator is going forward, the European Court of Justice is stepping back. What does it mean? It means basically that in a judgment of 2019, there is a different approach. I would say that the approach of digital colonialism, of digital imperialism is much less dominant, and there is a kind of spontaneous migration of constitutional ideas from Europe to United States. What I'm trying to say? I'm trying to say that in that case, the problem was how extended is the obligation to remove to the index what is against the right to be forgotten. And the dilemma was, it's a European extension or is a global extension? According to the Court of Justice, even if the GDPR, it was basically adopted or taken as example in Canada, in Colombia, in Chile, in Israel, in Peru, in Mexico, in Kenya, in Russia, and in California, despite of this, there are states in which this kind of mechanism, this kinds of application is not known. So this is a kind of deference in relation to a digital pluralism. Last point, if it's true that there is a new approach by the European Court of Justice, much more willing to learn and not only to teach with regard to digital law, a good lesson can be taken by the Supreme Court, in particular, the case law of the Fourth Amendment, in particular, the case of Jones, in particular, the great intuition of Justice Sotomayor with regard to the mosaic theory. Because the European constitutional data protection is still slave of the data personal matrix. If it's not a personal data, it's not within the scope of application of GDPR. Well, a Fourth Amendment, as interpreted by Sotomayor with the mosaic theory, shows that it's possible to go beyond personal data. It matters quantity because it's important if it's a search in isolation or if it's a group, a series of search. This means basically that in this new season of mutual learning, I think that a good lesson can be learned from a provision written in 1791 that is more technologically fit than the infamous GDPR. Many thanks.
Thank you very much, Professor Pollicino. That was very enlightening, and it's always interesting to hear a different perspective. So thank you very much for that. I'm going to keep us moving and introducing our final presenter today, Margot Kaminsky. She is an associate professor at the University of Colorado Law and director of the Privacy Initiative at Silicon Flatirons. She is also an affiliated fellow at the Information Society Project at Yale Law School and a faculty fellow at the Center for Democracy and Technology. In 2008, she researched comparative and transatlantic approaches to censor privacy in the Netherlands and Italy as a recipient of a Fulbright Schumann Innovation Grant. And she writes extensively on issues regarding privacy, data protection, and a whole lot more. So without further ado, Professor Kaminsky.
Thank you so much. So I'm the one person who's going to be using a slideshow, mainly because I wanted to provide some extra visual interest. And today I am going to talk about a co-authored piece that I've written recently with Meg Jones at Georgetown called An American's Guide to the GDPR. So this piece is forthcoming in the Denver Law Review. I'm very grateful to my fellow Coloradans for deciding to accept this piece. And the basic concepts behind it, it's only around 30 pages, and we created it primarily to be a teacher's tool. The basic concepts behind it are that the GDPR is very long and complex, and US audiences often completely misunderstand it. And they misunderstand it in some very predictable ways. This matters because the GDPR is often referred to, including by wonderful scholars such as Neil, who never gets it wrong, sometimes as a straw man in conversations about potentially new US privacy laws. So from our piece, I wanted to read this short section. If part of the discussion of whether or not to enact US law that mimics the GDPR, then we should know what it is that we are copying or rejecting. So the following are some common claims about the GDPR from US readers. The first is that it gives individuals complete control over their personal data. The second is that the GDPR creates a property right in personal data. And the third is that the GDPR, there we go, is primarily based upon principles of notice and choice. So you'll notice in all of these are actually things that might be true about the GDPR, but are said in a way that is rather absolutist. The GDPR gives individuals some control over their personal data. It creates some rights that could be semi-property-like, and it does have elements of notice and choice, but it's definitely not primarily based upon them. And finally, there's the common overclaim from US audiences that the GDPR in the end is all about individual control. So in this presentation, I'm going to run through some data protection law basics. And I'm going to talk about what the GDPR actually contains with an eye towards influencing discussions about US policy. The first big point is that data protection and privacy are not the same thing. They are overlapping concepts. And here I'm discussing both laws in the United States and in Europe. But in Europe, there's a much more robust literature discussing the distinctions between these two things. So they're overlapping concepts, but they are not coextensive. Somebody's going to kill me for this slide. What privacy is, there is a robust literature about this. And I want to be very clear that I am not navigating that literature in any detail in one slide in a 14-minute presentation. But in the US, when we talk about privacy, what we often mean, and by we, I actually mean probably not the data privacy community, but the colloquial community, including legal community, thinking of what privacy means, is that we are protecting individuals from the dissemination of a particular piece of harmful information. So historically, privacy in the legal sense might be understood as being the Prosser torts with all of the issues that they face in navigating a data privacy world or a world of big data. So first, there's this idea that we protect individuals from the dissemination of one piece of harmful info, or we protect against surveillance. We protect against particularly intrusive information collection, including by the government. Data protection is more akin to what we understand in the US as being information privacy or data privacy. And these are protections that attach to data sets or large accumulations of data that are stored and analyzed and processed and used en masse. And this is a slightly different set of issues and a different set of policy tools than when you're talking about historic privacy. And they raise systemic concerns about power, about fairness, about accuracy, and about accountability. Data protection, in other words, checks power. It can be understood as the rules of the road for processing data rather than a ban on processing data, although we'll get to the ways in which the GDPR does in fact start from a ban and then move into rules of the road. And data protection, this is key for conversations in the United States that involve the First Amendment, can be understood as being as much about increasing information flows as decreasing it. There are US laws that are more data protection-y. We think of things like HIPAA or COPPA. And Bill McGivern one of my co-authors, has a wonderful piece outlining the ways in which some of these US laws can actually be understood as being data protection models. And those are laws that are built around the fair information practices and emphasize largely transparency and information flow. There's also, and this is often misunderstood by US audiences, European law that protects privacy in a more historic privacy sense. That really is about stopping the flow of a particular piece of sensitive personal information. And some of that law, in fact, a great deal of that law exists in individual member states outside of the GDPR. Data protection in the EU is a fundamental right, as has been noted. And that fundamental right is outlined in both the European Convention on Human Rights, Article 8, which protects privacy and has been interpreted by the European Court of Human Rights to also protect data protection, and the EU Charter, which has Article 7 and Article 8, which explicitly protects data protection separately. I'm going to go back to my first claim from this slide, which is that just because data protection is a fundamental right, it does not make it an absolute right. And this is mind-boggling for US audiences. So when a court in Europe says that there is a fundamental right to data protection, this sets up a balancing test between that and other fundamental rights and also other interests. The EU Charter Article 8, right to data protection, is as follows, roughly. So it's a right to protection of personal data that must be processed fairly for a specified purpose. So there's your purpose limitation right there in fundamental human rights law, either on the basis of consent or, and this is very important information or very important language that again, US audiences largely miss, some other legitimate basis. I'll come back to that shortly. And compliance as a matter of fundamental rights must be handled by an independent authority. So if you look at this from a US perspective, immediately what comes to mind is that many of the ways in which we address data privacy do not include having a separate agency. This makes the CJEU the enforcer, interpreter, and backstop, as Neil mentioned, to anything in the GDPR. So the GDPR may delegate a significant amount of enforcement to what looks like self-regulation, but in fact, there is a human rights court behind that that is willing to be the backstop and put limits on what corporations can do. Another important point is that none of this is new at all in Europe. Some EU member states have had data protection laws since the 1970s. The Convention 108 has been in place since 1985 and was recently revised. And the Data Protection Directive, the predecessor to the GDPR, has been in place since 1995. And then you have a substantial body of human rights case law, both the CJEU and the European Court of Human Rights. So what the GDPR contains, and I am willing to have this challenged. A lot of the stuff that's in the GDPR just echoes what was in the directive. So again, a lot of it isn't new. If you are a European or if you're in another jurisdiction that has similar data protection law to Europe. And the directive established some fundamental conceptual categories, such as the categories of data controllers and data processors, which are the entities that are subject to data protection law, along with a series of FIPS-based individual transparency and other rights, and the concept of lawful processing, which again, I'm still putting a teaser in there to say I will come back to that. The way the GDPR primarily changed things in the EU is that it's much harder law. So directly binding upon member states, it toughens, and again, as Oreste pointed out, it doesn't fully harmonize, but it toughens EU-level harmonization mechanisms. And it creates much bigger penalties, which is why corporations around the world sat up and took notice. I can't tell you how many companies in Colorado have come to ask me about GDPR compliance. So this is the really dangerous slide. I'm going to give you the GDPR in one slide. One, it covers all entities that process personal data. This includes both those entities that directly control processing of the data and those that process data on behalf of another entity. So you can think of your website, your company, and then the website builder as being the data processor. The GDPR requires that individuals be afforded certain individual rights, which include the FIPS. And it imposes affirmative obligations on companies. This is, in my view, and the view of several others, probably the most important ignored aspect of the GDPR. So how the GDPR differs fundamentally from US law is as follows. Much of US data privacy law is consumer privacy law, which focuses on a relationship between a company and a consumer and the representations that that company does or does not make. And by focusing on that relationship, as we saw from reports from the FTC and the Obama administration, it doesn't reach third parties. It doesn't reach data brokers, or it makes it much more challenging to reach data brokers. The GDPR, by contrast, follows the data regardless of who holds that data. And it stems from the very basic premise that any entity that holds personal data, with a list of exceptions, cannot process that personal data unless it does so on a lawful basis. It is not primarily based on consent. I'll say that one more time. It is not primarily based on consent. Consent can be a lawful basis for processing data under the GDPR, but most companies, for a variety of reasons outlined in our paper, choose to process it instead under the legitimate interest basis. That is both fuzzier than consent and in some ways creates a regime that relies significantly more heavily on voluntary compliance or co-regulation by companies. So this is the other half of the GDPR, and I think this actually meshes really nicely with some of Stacey Ann's parts of her presentation earlier today. The big second half of the GDPR is company compliance. This is what often gets ignored in the United States. It's one of the 5 principles of the GDPR, the principle of accountability. So think something more like banking as a regulated field, as opposed to something like, the collection of information in the United States by a website. The principle is that not only do you have to comply with the GDPR, you also have to prove to a regulator that you're in compliance. So the substantive aspects of this include data protection by design and default, which for those who are not familiar with it, basically means build your technology and build your corporate practices around basic principles of privacy and default to not over collecting information unless you have a really good reason for it. But the proof that you're in compliance portion of this involves extensive corporate infrastructure, including both record keeping, data protection officers for many companies, and impact assessments or risk assessments before doing high risk data collection and processing. And this as a whole attempts to influence not only technological design, but also corporate design, corporate governance. So in closing, when you look at the GDPR from this perspective and see that it has these 2 portions, and you compare it to new and proposed US data privacy law, both on a state level and on a federal level, you find that for the most part, US privacy law, including proposed law, largely misses the second half, this emphasis on corporate compliance. And I have a piece on this with Anupam Chandar and Bill McGevern forthcoming in Minnesota Law Review called Catalyzing Privacy Law that compares in much greater detail the California Consumer Privacy Act, the CCPA, to the GDPR to show that the CCPA, by contrast, is largely a transparency law that emphasizes individual action and individual rights and primarily misses the corporate governance aspect of data protection. Now, normatively, I think that's a big mistake. I think that reliance on corporate governance alone is not enough, but reliance on corporate governance is essential. And when we look at proposals for data privacy laws in the US that propose only one or the other, corporate governance or individual rights, we don't have the full picture of what should make data protection law work and makes it more effective. So with that, I'll close and turn to conversation with my fellow panelists. Thank you.
Thank you very much, Professor Kaminsky. I'd like to take a moment and just thank all of our presenters. I think we covered a lot of ground in a very short period of time. So I thank you all for such excellent presentations. I think at this point in time, we want to go ahead and open it up to questions coming in from the chat for the panelists. I'll give that a minute to kind of filter in. I will throw out a question if it's all right. Professor Richards, you talked a little bit about kind of externalities and these things outside of necessarily the privacy law context that we need to think about. One issue that I don't think anyone discussed is the intersection between privacy law or data protection law and growing monopolizations and concentrations of power. There's been a couple of papers out of the EU in the past several months that have reached the conclusion that the GDPR has further enhanced the power of large platforms, and that there's been even more condensed or consolidation of competition. So I just throw that out there to any of the panelists who may have a thought on this or would like to talk a minute about the relationship between competition law and privacy law.
Did you call on me, Randy, to start, or?
I threw it out there, Neil. If you want to jump in, I think it'd be great.
Sure. I mean, I should preface what I'm going to say by saying that I am not an antitrust scholar, right? And I think one of the really interesting things that we've touched on over the course of the last hour is the way that different legal frameworks are different tools that are suited to particular tasks. So if you want to deal with power, then a sort of power to individuals, then a fiduciary framework I think is a really good one. If you want to follow the data as it travels through data brokers, as Margot was just talking about, then a data protection framework is really good. And an antitrust framework, right, which was the beginnings of consumer protection in the United States with the passage of the Sherman Act over 100 years ago, was trying to deal with monopoly power. And I think whenever we're talking about different kinds of tools, we should be mindful that tools are heuristics, and heuristics are good at simplifying, and they focus on some salient features at the relative ignorance of other features. With respect to the immediate question, right, which is privacy / data protection, mindful of the distinctions that Margot laid out, but is this sort of approach to personal data, is it anti-competitive? And I think there is a risk that it could be, right? That if you have a highly detailed, sophisticated regulation that places a significant compliance burden upon an organization, it's going to be easier for big companies to comply with that than for smaller companies. That's not necessarily a bad thing, and it's certainly not a reason not to have privacy reform. But I do think that some of the competitive consequences of privacy law should be thought about, but certainly not at the exclusion of actually doing something about the demonstrable and clear problems that are in front of us.
Thank you. If I can jump on this, because it's really a question that is very close to my topic about digital constitutionalism. There is a forthcoming book for Hart Publishing in 2021, April 2021, towards digital constitutionalism. My research question is exactly what you let emerge before. So which kind of categories of constitutional law and antitrust can be borrowed in data protection? And I think I would like just to mention one phenomena and two categories. The phenomena is that there is a clear shift from the freedom to conduct business to being a private power. Basically, all those platforms are not anymore just conducting business, but being a private power. This is a great challenge for constitutionalism, because constitutionalism, it's about limiting power. It doesn't mean that it's public power or private power. And then two categories that are borrowed by antitrust. The first one is the concept of spatial responsibility. Those companies that are in dominant position are a kind of spatial responsibility that is not shared by the other company. It is something that is a very straight connection between antitrust and competition and constitutional law. The second category It's the effect theory. This has been developed in Google Spain by the European Court of Justice. The effect theory in antitrust means that it doesn't matter where is the server farm, it's important the effects. If the effects is provided in the European digital single market, then will be applied the GDPR. Those, you see that there is a kind of hybridization between competition law, data protection, and constitutional law. This is very interesting, I think, from an interdisciplinary point of view.
So I'll jump in next. I think that this is a really important conversation to be having, and there's some extraordinarily productive work to be done in collaborations between antitrust experts and privacy law experts. From my perspective, again, on the data privacy side of things, I would say yes and, right? Obviously, this is about issues of power, and obviously regulation of smaller companies creates power imbalances. The other big concern people have had about the GDPR is that it sort of cements in lower cost data sets for those companies that already gathered those data sets pre-GDPR, and a federal US law would do something similar. And anybody who is a new entrant into the market would have to deal with high cost regulatory compliance instead of having that existing low cost unregulated data set. So one thought is, why not regulate the existing data sets and impose those regulatory costs on the companies that already have them? The other thought is that we need to be having more serious conversations. I'm kind of surprised we haven't had them so much in the United States about the cutoffs for the entities that we regulate. So if you look at the California Consumer Privacy Act, it has a set of different definitions of what a business is. And regulated entities are categorized by both the number of people whose information they hold and the amount of profit that they make. I think in one category, it's a combination of those two things. So that is an attempt in the US space at getting at the larger companies, smaller companies problem, while also thinking about the purpose of data protection or data privacy law and trying to prevent certain kinds of harm. So I would say the CCPA model, which I'm not necessarily advocating, but think should be on the table for discussion, is to say, if you're a very small company, but you hold data for a lot of people, you should still be subject to regulatory cost. Or if you're a very small company, but you're making an enormous amount of money on people, then you also should be subject to regulation and cost. And the more difficult conversation, I think, comes when you're talking about small companies that process very sensitive information for a very small amount of people, what kind of regime those should be subject to, or large companies that process an enormous amount of information, of personal data, but it's really not core sensitive personal information. And the data protection model largely says that doesn't matter, especially when we're in a world of inferences and not very sensitive information can give rise to other more sensitive information. But that should be part of the conversation when we're talking about the overlap between data privacy regulations and antitrust.
So thank you. I'll jump in next. So with respect to this question about market power, now one of the things I talk about or address in the book is the role of mergers and acquisitions, right? How large tech companies are essentially mopping up these smaller IoT companies. So if we're talking about, for instance, the Ring or Nest acquisitions, right? So they're doing this to solidify their market power and also to consolidate data, right? If you look at the Amazon Whole Foods acquisition, for instance, as well, and also to in some cases, solidify or reap talent, right, from these smaller companies that are essentially then merged into larger tech companies. What that does also then is it creates an environment in which you have consumers that then have less choice in terms of the different platforms that they can access, right, and the different companies. There's also, as we know, some movement at the federal level to investigate large tech companies' acquisition activities, right? Something else I think to consider is that, antitrust law certainly has a role, and I talk about this in the book, certainly has a role to play. And that's one of the reasons that I advocate for a comprehensive approach, right? In the sense that we can't just rely on a data protection regime. We also have to look at other sources of law that impact various consumer privacy and security security issues. And antitrust law can be, an important source of law that can address those issues as well. And to address the question of the impact of the GDPR, I mean, there certainly has been significant criticism of the GDPR, some of which I'm sure is warranted, but there has been some empirical research that also suggests that the GDPR to some extent is can have a positive impact. So there was a recent study, I believe, that was released in 2019 comparing IoT devices in the UK versus those in the US. And they essentially found that devices in the UK transmit less data to third parties than IoT devices in the US, right? And the authors attribute that difference, right? They suggest that difference could be due in part to the different regulatory landscape in the US versus the UK. I mean, obviously we have Brexit. So I think that if we're talking about potentially importing some provisions from the GDPR into the U.S. Landscape, as I mentioned earlier, we can't just rely solely on those provisions. There are other aspects of the U.S. Legal landscape that would also need to be addressed as well. And the GDPR potentially presents an opportunity, to the extent that we're borrowing principles from the GDPR, presents an opportunity to learn from, the mistakes in terms of enforcement issues that we're seeing as well.
I'd like to thank you all for those answers and thoughts. That was enlightening and very helpful. I see that we're running short on time. I'll turn it back to Professor Barnes. Maybe we have one more question, or if not, I guess we can close out.
Yes, I was intrigued by this idea that Professor Richard spoke to, and also Professor Pollicino, regarding norms and human rights. And so human rights is informing the European framework, and then the possibilities of translating that, or at least infusing some human rights into a US regulatory regime. So I'm curious about the prospects of doing that. I'm picking up on what Professor Richards mentioned regarding his aspirations for modeling a U.S. approach where we would take into account protection of people, civil rights, environmental impacts, et cetera. So given that the U.S. does not have the same strong emphasis historically on human rights, what are the possibilities for developing that kind of approach here?
I have a very quick and crazy thought. One thing that I have thought about is, given the state-by-state enactment of privacy law in the United States right now, is that it would be fantastic to have states amend their constitutions to put in place data privacy protections in state constitutions. There's a lower hurdle to such amendments in some states over others. There's a historic precedent for this if you look at some states that actually have more robust than Fourth Amendment privacy rights in their constitutions. I believe both California and New Jersey come to mind. And that would sort of get us the experiment going, at least in state constitutional challenges, if not on a federal level.
I love that idea. I think, I mentioned at the end of my talk about my fears about a broadly preemptive but nevertheless weak federal privacy law. And I think this really is one of the areas in which, appropriate enough given his role in both privacy and the First Amendment, that Louis Brandeis's notion of the states of laboratories of democracy really has been effective, right? A lot of work done in California, where I believe the California Constitution does protect privacy as a fundamental right, but also a lot of great work done in particularly in Illinois with BEPA, but also Massachusetts and some other states engaging in privacy experimentation. And I think the human rights approach here is essential. It's an argument that I make if we're plugging books today, at the very end of my own forthcoming book called Why Privacy Matters. And ultimately where I come out is that we need to start talking about privacy at that level. Human rights discourse matters, right? You only have to look at the debate surrounding Section 230, which Professor Pollicino mentioned, to see how even in the United States, a law that is thought to be built upon a human rights framework, in this case, the First Amendment rather than the second First Amendment of the US Constitution, fundamentally changes the debate. And similarly, when we're talking about privacy, if courts begin to take seriously this nonsense idea that all privacy regulation is censorship that imperils democratic self-governance, then I think we're not going to get very far with privacy regulation in the United States. So I think that the key is to start talking about this as a fundamental right, to get recognition from whatever source is possible, whether it's state constitutional amendments, whether it's some notions of horizontal effect from the Fourth Amendment or even the First Amendment itself. And I think it's also just to push back as hard as we can on these ridiculous notions of overbroad First Amendment Lochner. The idea that a corporation's ability to make profits and to scrape data is so important that we can't protect human beings, and that if we try to protect them, we imperil the very foundations of democratic self-governance by violating the First Amendment. I think it's just an idea that has to be rejected, buried, and then the earth salted on top of it.
Professor Policino has something to say on this.
Yeah, thank you very much. Just to tell you my take on this very fascinating phenomenon of migration of constitutional ideas. I think that there is it's a time of, let's say, go beyond the taboo. The taboo is, let's say, the commonplace that European data protection law is based on dignity. And whereas all the human rights, let's say, data protection in the United States is based on freedom. This is very true historically. But today, I think that we should go beyond this, looking at the convergence between the dignity approach and the liberty approach. This is, I think, the real bridge that should be built.
Thank you. And I see that we're at time. So I want to, again, thank all of the panelists and the audience for a really stimulating conversation. And hopefully, for those of you out there, if you're interested in either one of our sections, European law or the section on defamation and privacy law, please get involved. Thank you again.
Thank you.